Hello and welcome to the Micklin Law Group's How-To series. As you may know, my name is Brad Micklin. I'm the managing member of the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices located in Nutley, Montclair, New Jersey. As you may or may not know, each week I do a series of different videos. I do a daily tip on my YouTube page and my website, giving you a small piece of information on like one specific topic. I'll then do one of these how-to series, which I try to do each week, which takes one larger topic and gives you, a little bit more of an in-depth analysis. Then each month I do a monthly webinar, which takes one topic and goes broadly into it for 40 or 50 minutes. So today's how-to series is how to calculate alimony in 2019 and going forward. So just so we're clear, this is being recorded in July of 2018. We're on the precipice of a very interesting change in the tax code in 2019 and going forward, where alimony is no longer going to be deductible. Now this is significant because for as long as I've been practicing and as many other lawyers have been out, alimony was always tax deductible and it was always based on gross income. So in the past, we would have a way of calculating it where we took the two incomes, the gross incomes, we subtracted them and took 1/3 of the difference. Now, I'm not saying that this was the best way or the most efficient way of doing it. As a matter of fact, there was actually even case law that says you were not supposed to do it that way, but everybody did because there was just no better way to figure out alimony. And since everybody had been doing it for so long, we continued to do it, right or wrong. So the main difference now is that alimony is not going to be based on gross income. It's now going to be based on net income. So the calculation has to be entirely different. Now, as far as I know, I haven't heard anybody comment on how we're actually going to do this yet, but I have a couple ideas of how I'm handling it with clients going forward. First thing I'm recommending is that you do a hypothetical tax return. Aside from the fact that alimony is not deductible anymore, there are several changes to the tax code that are coming into effect in 2019 that will affect the alimony calculation. First is there are new tax rates. So before, the advantage of having tax deductible alimony was that we often allowed us, because of the different tax rates between usually the paying spouse and the receiving spouse, it allowed us to shift income because of the tax savings. We don't have that anymore. So now we have to look at the net income. So we have to first do a hypothetical tax return by looking at the new tax rates. There's also going to be or could be a loss of some, if not all, of the real estate and mortgage interest deductions that we had in the past, which will now impact your actual net number. And then lastly, there's some changes in the child-related deductions that we used to get. So all these changes together are going to impact the tax return. So I recommend that we do this first, so we're looking at what the net number is, because again, that's the number that we're going to be using alimony from. Second is we now have to look more closely at the case information statement. In the past, this document was always filed in a divorce case, and in my opinion, it's probably the most important document, but it's rarely been used when calculating alimony. Again, everybody would take the income and the difference, and that was just the easy way of doing it. Now we really have to look at the spouse's needs, the lower earning spouse's needs, and how they're going to change in the future. So the CIS needs to be really, really thoroughly reviewed. Lastly, we're going to need some way now to determine the need based. Just reviewing the case information statement and the tax returns are going to leave you the numbers that are needed. It's going to tell us what income is available for paying and what income is needed. Now we don't know how to bridge the gap between the two. It's possible that we might go back to this 1/3 analysis, or maybe even a new sort of rule of thumb is going to surface, but right now we don't have one. So you got to really carefully prepare the hypothetical tax return and also review if your adversary or the other party is creating one, review their tax return to make sure that it's accurate. So we're dealing with the right net numbers and make sure that the expenses are accurate. From this point on, I'm not really sure what we're going to do with it. It's going to be, for at least practitioners like me, it's going to be a little bit of an exciting time because it's a change and it's a new area for all of us. So a lot of us are going to be on equal footing before, whereas you might have had divorces for a long time in the past. You might have had attorneys who were practicing decades before you, and now we're all going to be on equal footing, and even the litigants are going to be on equal footing because nobody's going to really know what to do, and it might actually hopefully cause a greater level of cooperation. For more information on this alimony issue and the tax code changes, go to my website, which is micklinlawgroup.com. That's MICKLIN, lawgroup.com. It's all one word. You can call me at 973-562-0100 if you'd like to schedule a consultation. And for more of these videos and the ones I referenced earlier, go to my YouTube page, which is Brad Michael Micklin. Thank you.